My name is Alex and I am an avatar here on behalf of attorney Carola Lawson to talk to you about estate planning and the documents you need. Maybe you're ready to compile your information because you have gone through a loved one's belongings and don't want to leave the same mess for your kids. Have you had a parent pass away and needed to settle their estate? Or perhaps you're ready to compile your information so that you can have conversations with loved ones now. Getting your information together will help you understand where you stand and when important conversations are needed before there's an emergency or you die. I'll break it all down, the most essential pieces needed for gathering your documents for your legacy planning. We will also talk about how to create your own personal legacy notebook. I'll tell you how to create a legacy plan even if you're on a budget and what legal forms you must have. What are the 3 most common lies regarding estate planning? Lie number 1 is it's all or nothing. You don't have to do it all at once. You don't have to understand it all today. Let's go over the lingo of the documents and people you need. Your estate planning team, your documents, and your storage box. Your estate planning team, in the event of an emergency or death, other people will need to step into your life in order to get your emergency and end-of-life documents in place. This is who you will need to identify and healthcare surrogate, attorney-in-fact, guardian or guardian if you have dependents, and personal representative for your will and a beneficiary or beneficiaries. Let's talk through what each of these team members is responsible for. Your healthcare surrogate. This person will oversee your medical wishes in case of an emergency. So for example, if you are in a bad car accident and are in a coma and can't speak for yourself, your healthcare agent's job is to ensure that your medical wishes will be followed. The attorney-in-fact is your financial agent. This person will handle your financial affairs in case of emergency. So going back to our previous example, if you're in a car accident, your financial agent would keep your bills paid and make financial decisions while you're in the hospital. They will have access to your bank accounts and be able to sign your checks. Guardians. This is the person or persons who will step in to take custody of your person if needed, or to care for your dependents in case of emergency or in case of death. Dependents are underage children, adults with special needs. Naming a guardian will give you peace of mind that there's a plan in place for everyone. Your personal representative. This person will oversee the wishes of your will in case of death. Lastly, beneficiary or beneficiaries. This is the persons or entity named to receive distributions from a trust, will, or life insurance policy. This is who gets all of your assets. So if there's an emergency, then you have your healthcare agent to follow your medical wishes if you're unable to do so for yourself. You have your attorney-in-fact to take care of your finances if you're unable to do so for yourself, and you have guardian or guardians to take care of any dependents if you're unable to do so, or you if you are unable to do so. When you pass on, then you have your guardian or guardians for any dependents, your personal representative to oversee your end-of-life wishes, and your beneficiary or beneficiaries to inherit your assets. Those of your legacy team could all be different people, or one person can serve in multiple roles. For example, your attorney-in-fact could be the same as your personal representative and healthcare surrogate. It's also important to have 1 or 2 backups for each of these roles. So for example, if your chosen personal representative unable to fulfill their role at the time of your passing, there's someone else who can step in. So now you have your team. The basic estate planning documents you need are last will and testament, healthcare power of attorney, living will, HIPPA release form, and your durable power of attorney. Your last will and testament is for when you pass on. This document will name your personal representatives and your beneficiary or beneficiaries. Your healthcare power of attorney is for in case of emergency and will name your healthcare surrogate. Your living will direct your wishes regarding prolonging your life when you are unable to have a say. Your guardianship documents will name who is to be the guardian of your person should you need one, or the guardian of your children or special needs adult. Your durable power of attorney is for in case of emergency and will name who your financial agent is. All of these documents should be prepared by a legal professional whose practice is estate planning or elder law. The next issue is, what do I do now that I have all my documents? How do I keep them safe and easy for my loved ones to find? Your box and documents are in one location and house all of your essential information. We recommend using a fireproof and waterproof safe in your home. Safety deposit boxes will be sealed upon your death and only opened by court order unless they are joint with another person. On our products and reference page of our website, carolawsonpa.com, we have a link to the boxes we recommend. Having a simple plan in place is much better than having an elaborate plan that's not finished yet. Now is the time to get your simple plan in place. Contact our office at 727-410-2705 to schedule an appointment. Without a will, guardianship, and powers of attorney in place, your wishes will not be carried out. You risk guardianship of your dependents being given to someone you do not approve of or them becoming wards of the state, along with fights over your assets by family members and expensive legal bills for your family. These are just a few of the things that can happen without essential documents in place. The second big lie about estate planning is it's cookie cutter and you can just download forms and fill in the blanks. Wrong. Remember the adage, you get what you pay for. Have your documents drawn up by a legal professional so they are prepared correctly. A unique plan and secure place for your information is essential. Your loved ones need to be able to find all of your documents in one place when they need them. First, create your legal documents. Create a personalized notebook or file for your information. Second, create a summary sheet of where your information is located, how to access it, and how it's organized. Do this for your phone contacts, your passwords, digital accounts, and financial accounts. Put these summaries in your estate planning binder with your legal documents and important papers such as birth certificates, military discharge, social security cards, adoption records, final judgment of dissolution of marriage, passports, and military discharge forms. Lie number 3 is it's not affordable. Professional advice, such as attorneys, accountants, and creating legally binding documents can be expensive depending on your needs, but it is still more affordable than court proceedings. A basic estate plan without a trust will cost you between $350 and $600 per person for the documents mentioned here. Call our office at 727-410-2705 to schedule an appointment.